In this session, we will see about the rights of the surety. Section 140 says the surety has a right of subrogation. Subrogation means once the amount is paid, he will get all the rights of the creditor. He is stepping into the shoes of the creditor. Whatever right, the securities he had, everything will be passed on to the surety. That is, he can enforce the security. Whatever rights he had, that will be coming to him. Now we will see what are the rights before payment. Before payment, he can compel the debtor to pay. He can ask the debtor, you pay. He can send a notice and he can sue on behalf of the creditor also. For example, in one case, debtor was selling the property. For the due date, you want to dispose of everything. For example, it is a 1 year loan. The payment will be due after 1 year. But what the debtor was doing means he was disposing all his property. The creditor went to the court and he got injunction. The court restrained the principal debtor not to sell his property or transfer his property. Section 145 gives the right of indemnity to the surety. Indemnity means we have already seen, that is to save from the loss. If a person has suffered a loss, the other person, the indemnifier, has to save him from the loss. In this case, what is a loss? It is a loss money paid to the creditor. This surety on behalf of the principal debtor has guaranteed the amount. Since the principal debtor has not paid the money, or since the principal debtor has not performed the promise, the surety is compelled to perform it, compelled to make a payment. The loss occurred on this should be indemnified the principal debtor. The principal debtor availed a loan of 10,000 rupees. He has not remitted. Surety has remitted 10,000 rupees. That means the principal debtor has to indemnify the surety with that 10,000 rupees. Now we will see what are the rights of the surety against the creditor. Against the creditor, one is he has a right over the security. He can ask to share reduction and a right of set-off. We will see first security. Section 141 deals with this. What are the securities available to him should be passed on to the surety on payment of the money. Whether the surety is in knowledge of that is immaterial. If the creditor has done some act which made the security useless, in that case surety will not be liable. M. Ramanarayan versus State Trading Corporation. Some bill of exchanges were given, but the creditor made the bill of exchange useless. He should have on dishonor presented it. He should have on dishonor. He should have sent a notice, noting, protesting. Everything legally should have been done. Nothing was done. In the process, the bill of exchange was useless. In that case, surety was not held liable because it is the act of the creditor which made the security non-available to the surety. Then, the creditor has a duty not to burden upon the security. For example, one person availed 10,000 rupees, gave a security of 1 lakh rupees. The surety will be thinking it is only 10,000 rupees against 1 lakh, there will not be any problem in getting back the money. Subsequently, if the creditor gives extra money, about 80,000 rupees, making the total outstanding to 90,000, the other person will not be making payment of 90,000 rupees. So, burdening the security without the knowledge of the creditor makes the surety not liable under that. In Force versus Jackson, there was a loan of 200 pounds sterling. Subsequent to that, without the knowledge on the same security, the banker gave additional money. It was held that it is only 200 pounds sterling. The surety will give and he has to release the security. The surety gets all the rights of the creditor. He can file suit. He can proceed against the security. He has a right to keep the security after payment. In any case, if there is a loss of security, only the creditor has to bear the loss, surety will not be liable. Next is if there is a reduction in the liability of the principal debtor, it has to be shared with the creditor. For example, 10 lakh rupees loan, he was declared as insolvent. Against 10 lakh, the official assignee paid only 1 lakh. That means only 9 lakhs to be recovered from the surety, because the other 1 lakh he has already paid. In Hobson versus Boss, in this case the creditor collected money from the guarantor. Subsequent to that insolvency officials sent money, he took that also. It was held no, it should be shared among all. Next is the right of set-off. Set-off means if there are two things, it has to be clubbed together. For example, a person availed a loan of 1 lakh from the bank and he had a deposit of 10,000 rupees. It is a banker's duty to use the set-off first. The right of set-off should be used first. He has to bring that 10,000 and reduce the outstanding to 90,000, and only 90,000 should be claimed from the surety. This is right of set-off. It should be adjusted. Anything payable, anything paid should be adjusted, and the net amount should be recovered from the creditor. Creditor has a right to ask the surety has a right to ask the creditor, you first exercise your right of set-off, combine all the accounts and then claim the money from me. Now we will see what are the rights against the co-sureties. The account may be guaranteed by 2 or more persons. Banker may give a loan to A, B and C may guarantee that. The creditor has a right to proceed against the debtor without proceeding against the creditor. The creditor has a right to proceed against only one creditor, leaving all other creditors and principal debtors without suing. That he has a right, he can proceed against anybody. Against the debtor or against the creditor or against both the creditor and debtor, or leave some surety without proceeding. In this case, if in a case where if the only one person paid the money on behalf of the other co-sureties, he has a right to claim them. In the example already taken, A borrowed money, B and C guaranteed. The bank sent a notice and collected money from B alone, means B will collect the equitable share from the other person. 50% share will be collected from C. Now B and C has paid. Both will proceed against A to recover the full amount. I will tell you once again. 1 lakh loan, A availed. B and C guaranteed the loan jointly. But the bank pressurized and got money only from B. B paid 1 lakh. Now B can claim 50,000 from C. Now B and C have paid 1 lakh. Both will proceed against the principal debtor A and collect the money. That is, they have to give their contribution equally. If the amount is for different sum, then also the amount should be contributed equally. This is regarding surety. Now we will see a difference between the surety and the bank guarantee. Guarantee is given in case the other person fails to perform or fails to meet the obligation of payment, obligation of liability, not meeting the liability. But indemnity is to save the other person from some loss which may or may not occur. In this case, in case of this default of a person, the surety comes into the picture. In the other side, in case of loss, the other person comes into the picture. If you see, there are 3 persons in guarantee. One is a principal debtor who has borrowed. One is the creditor who has given money. The other person is the person who has guarantee, who says that I will make a payment or who says I will perform in case of his default 3 persons, but indemnity only 2 persons. In indemnity only one agreement between the indemnifier and the indemnity holder. But here there are 2 agreements. One is agreement between the borrower and the creditor to borrow money. Another is agreement between the creditor and the surety giving the guarantee agreement. This agreement will be coextensive with that of the borrower. Borrower's agreement and guarantee agreement is coextensive. In the other case, agreement will not come into life unless something happens, unless the loss happens. In the next session, we will see some other topic.